Good morning, everybody. Welcome to the Indigenous Media Zones event. And today we are speaking about national human rights institutions and regional human rights mechanism advancing indigenous rights. And here as the panelists, we have the following persons. Can you introduce yourselves really quickly?
Sure. Do I start?
Yes, go ahead.
I am Marjolaine Alwell, and I work at the Inter-American Commission of Human Rights, specifically at the Reportership on the Rights of Indigenous Peoples.
Yes, and I am Johan Strömgren. I work at the Norwegian National Human Rights Institution.
Yeah, good morning. My name is Francis Johen, Anak Adam. I'm a commissioner of the Human Rights Commission of Malaysia, or in short, SUHAKAM. I happen to be also an indigenous person in Malaysia, one of the indigenous groups. I belong to the people we call the land Dayaks, people of the land, or in our own dialect, the Bidayo in Malaysia.
Okay. Thank you for the introductions. And my name is Nuorgam, and I'm member of the Permanent Forum. Okay, so today we are going to discuss about the regional human rights mechanisms. And my first question is on general level. So how does the national human rights promote and protect the rights of indigenous peoples? And what are the actions undertaken by the institutions, particularly in the recent years? Please start with you could start.
Sure. In general, with regards to land rights or with regards to human rights defenders, is there any specific topic or just generally?
Generally first.
Okay. Well, the Inter-American Commission on Human Rights works on a lot of different topics, of course, right? So it's a regional mechanism. What we do is there's different aspects. So what we do is receive petitions and cases from victims that are complaining about human rights violations committed by states. So that's one of the aspects of what we do. The Commission filters the cases before they are brought before the Inter-American Court on Human Rights. But we also have reporterships that work specifically at promoting and trying to guarantee the rights of specific populations that are considered to be particularly vulnerable in the Americas. And so since 1990, we've had a reportership on the rights of indigenous peoples that does a lot of work both providing specialized opinions in the petitions and cases systems, providing specialized opinions on the rights of indigenous peoples with precautionary measures, which is one of our mechanisms when either a person or a human rights defender would find themselves at risk of serious and grave harm or risk of irreparable harm to their human rights. We emit press releases. We write diplomatic letters to states to try to encourage them to comply with the Inter-American Standards on Human Rights. I'm trying to think of. We have many mechanisms that we work on, and we draft also thematic reports. I think that's important because I know I'll probably be touching on that further on the next questions. We've recently launched a report on the extractive industries, extractive, exploitation, and development industries and their impact on the human rights of indigenous peoples in the Americas, and also another report on the situation of indigenous women in the Americas and the particular human rights violations that they face, structural discrimination, trying to guide states on what are the standards in that regard and how they could help include indigenous women in all of the decision making that relates to their rights. Anyhow, I don't want to speak for too long. So I think that's a brief introduction generally of what we do.
Thank you. And Johan?
Yeah, thank you. At the Norwegian National Human Rights Institution, we work with the Sami peoples, the indigenous people of Norway, and their rights. We have two offices, one in Oslo and one in Kautokeino, located in the Sami living area. And we try to be a professionally strong actor is crucial to us. And we also work as a watchdog and a bridge builder between the authorities and the civil society. We have in last year we presented a report, a special report on the Sea Sami rights in the northern part of Norway, and we came to the conclusion that the Sea Sami rights should be historical rights to fisheries in the sea area should be protected by law and not only through administrative measures as it is today, and also that the Sea Sami should have increased influence in the increased participation in the decision-making system. So it was last year. This year we have just reported to the Norwegian Parliament in our annual report for 2017. We have highlighted that the problem that Norway has been implementing ILO Convention 169 regarding land rights and the recognition of Sami land rights only in the northernmost part of Norway, the Finnmark county. And it means that a very large part of the Sami living area in Norway hasn't yet received the same provisions on recognizing Sami land rights. That means in the more southern area of the Sami living area. So we have, so that's a problem when Norway doesn't fulfill the ILO convention in those parts. Besides reports, we also highlight other issues such as infringements on land rights, and problems regarding reduction of reindeer husbandry and other themes. So besides the reporting, we do quite a lot of seminars on different themes. We have highlighted right to freedom of speech and the problem with hate speech towards indigenous peoples. We have highlighted also the unfortunate problem with domestic violence within our own people. So that's a picture of what we are doing.
Thank you. First, I'd like to introduce the formation of our commission. The Human Rights Commission of Malaysia, or SUHAKAM, was established in 1999 under an Act of Parliament, but became operational in April 2000. So under that Act of Parliament, it specifies what is human rights, what is our scope, which refers to the fundamental liberties under Article 5 to 13 of the Federal Constitution of Malaysia. But we also refer to the Universal Declaration of Human Rights in the scope of our work. Now, under the Act of Parliament, under which SUHAKAM was set up, it specifies the functions and powers of the Commission. Basically, we have four main functions. Number one, to promote human rights and education through education. Number two, to act as advisory to the government on formation of law and administrative policy. Number three, we encourage or urge the government to ratify the main human rights convention. There are 9, but at the moment, Malaysia only ratified 3, CRC, CRPD, and CIDO. And number 4, which is a very important function, which relates to the indigenous, is we have powers to receive inquiry and to receive complaints on alleged violation of human rights, particularly including those against indigenous people. So we have powers to conduct regular checks and visits to places of detention. We write reports, thematic areas, and at the same time, we conduct seminars to promote through education. And our commissioners are people from different backgrounds. Like in my case, I was a former government servant in the state of Sarawak. My last post was as Deputy State Attorney General, so dealing with mostly state rights. Malaysia is a federation, so there are division of powers between the federal government and the state governments. But the federal government is more powerful. State governments have only powers related to land, local government, customs, local customs, forestry, and all that. So, but the major function is with the federal government. Now, apart from that, when it comes to appointment of commissioners, like I said, we are from different background. There are 20% commissioners can be appointed. But because of a budget constraint, they only appoint about 7 or 8 per year. I started about 6 years ago, 2013, 3 years appointment now. It was reappointed in 2016 up to 2019, so I have 1 more year to go. So I'm in my second term, which is the maximum, 2 terms, 3 years each. And so relating to rights of indigenous persons, what we do is basically to promote and protect the rights of everybody. Our theme is, rather our slogan is human rights for all. That is what we want to implement, which covers especially vulnerable groups, just like indigenous people. And what we do is basically we conduct talks, either in groups or smaller groups or bigger one, with the community to raise awareness on their rights. Number 2, we receive complaints on the alleged violation of trespass to the land by private companies and extractive industries. And one important major project we did was to conduct a national inquiry on the rights of indigenous persons in Malaysia, covering the aborigines in Penang, Malaysia, the natives of Sabah and Sarawak. In Sarawak, where I come from, there are 28 main groups, indigenous groups. But if you include the smaller groups, it can be about 30 plus. In Sabah, another state next to Sarawak on the island of Borneo, there are probably almost a similar number, more than 20. So each have their own various functions and practices. But the important thing is land, forestry, and the territory where they live is very important as part of their lives. So that's the issues which arise from that is what the Commission is dealing with. So every year we also our annual report, which we submit to Parliament during the first session of every year, which includes whatever activities we have from January to December of each year. And at the moment, we encourage the Parliament to have a special debate, but so far has not been successful. But each individual members of Parliament can pick up issues in our report as part of the debates in the Federal Parliament, in the Assembly. So that is what I can share. And then apart from that, we are dealing with various issues affecting indigenous people, documentation of their citizenship, birth certificate, identity cards. These are very important documents because it affects their rights to health, education, and even freedom of movement. So these are areas where we pick up. We will liaise with government agencies to try to get feedbacks and at the time make recommendations. And with regards to national inquiry, actually we have 18 recommendations covering security to land, and then legal mechanism to decide disputes and all that. But the government, when we submitted the inquiry was done in 2010, completed in 2012, submitted in 2013. So the government set up a task force to study our recommendation, 18 recommendations. And at the end of the study, 2 years, almost 2 years, the government accepted 17 out of 18. The last one dealing with the proposed commission on indigenous people in Malaysia was not accepted. So the report shows that there are follow-up action to be taken to be implemented in short-term, medium-term, and long-term basis. So that is the main issue when it comes to the main work of the Commission dealing with indigenous people on land. Thank you.
Thank you. Each of you mentioned several procedures or you have in your institution. What is the most effective for the indigenous peoples of those procedures you mentioned? Just shortly, yes.
That's a difficult question. We know that at the international or inter-American level, or both really, we struggle with implementation at times of standards of human rights. I think that, however, I must highlight that at the inter-American level, the petition in cases systems has really brought to some groundbreaking and historical decisions with regards to the protection of indigenous people's human rights. And there's been some landmark cases that have been later on even studied and interpreted and used in other regional and at the universal level. And so I think that would be one of the most effective, but I also think that these need to be accompanied by monitoring mechanisms that at the reportership we're in charge of. So it's not just a question of only relying on the petitions and cases systems, but also, for instance, on, and it's something I forgot to mention earlier, but on the hearings, thematic hearings, for instance. So if Indigenous communities want to bring attention to one of the, to a situation in their country, whether a specific situation or a more general, widespread problematic that could even be regional at times and embark more than one country, they could come to the Commission and request for a thematic hearing to be held to inform the commissioners, and in particular the rapporteur on the rights of Indigenous peoples, who's Antonia Urejola from Chile, and inform them of the situation, for us to make sure that we could supervise the situation, keep an eye out on it, and if ever necessary, to use others of our mechanisms, such as press releases, to try to call on the government to avoid reproducing this violation of human rights or stuff like that. I think it's also worthwhile mentioning that we also have a very important role of in Spanish we say capacitating. I guess it would be training in English, training with regards to human rights, and so that could also be something that's very useful and effective, where they ask the Commission or the rapporteur to go at a conference and try to explain what the inter-American standards are, for people to know what the mechanisms are that they can use, how to implement them, what the standards are. So that's another one of the very important and also effective mechanisms that we have.
Yeah, thank you very much. It's a very, I agree, it's a very difficult question to answer, and in our case in Norway, it's specifically because we have been up and running only in 2 years now, so we haven't seen the follow-up from our findings and suggestions to the authorities and the Parliament. However, I like to believe that the reports we're working on and the suggestions we're putting up we're giving to the Parliament and to other authorities, that they will be properly followed up, and if they are, that would of course contribute quite a lot to the advancement of Indigenous people's rights, I think. Another area that we work with is counseling to the authorities. So, and that's foremost in specific cases, in hearings before adoptments of acts in the legislative work, and also the authorities, the government and the Parliament, and also the Sami Parliament can ask us for advice in specific cases. So we have also been giving advice to the Sami Parliamentarian Council on the theme of the Nordic Sami Convention, for example. Yeah.
Thank you. How about Human Rights Commission of Malaysia, your work?
Yeah, thank you. When you talk about the mechanism, we talk about the two parts. One, to me, is the formal mechanism, and the other is informal. When you talk about the formal mechanism, it includes the existing legal framework and also the policy of the government in power, and the laws. Because these laws or legislation, both at federal and state level, in the case of Malaysia, would specify what are the rights of indigenous people, especially with regards to land, forestry, and the territorial domain in which they live. So in that also they specify the scope and to what extent they can seek legal redress through the courts, mostly to the courts. The courts, we have the civil courts. So when there are cases involving the people, the indigenous people and the government, they will refer to the civil courts, the high court. But when it is land disputes between two individuals, indigenous people, they refer to the native courts, they call it, the indigenous courts for dealing with all these cases. So they are formal system. So that is the formal way to seek redress. Of course, within that administrative framework, there are officers like the Land and Survey Department, which administers land matters, which we can refer disputes. Or there are administrative officers at the district and residential level, because the state in where I live are divided into region. So there are an officer and administrator. So they act as to facilitate discussion between individuals and private companies, which alleged violates the land rights of indigenous people. So these are so-called part of the formal structure. Now, when you talk about the informal structure, within the SUHAKAM itself, in our commission, like I said earlier, our powers is to monitor and propagate and educate on human rights. So we use that sort of avenue to provide sort of information and advice. At the same time, encourage them to seek their own ways to organize themselves, number one. Number two, we receive complaints. So based on that complaint is a starting point for us to inquire into alleged violation of the indigenous rights, especially regard to land and other issues which affect them. And we do follow-up action with relevant government authorities. In that way, we provide a recommendation, or sometimes we refer to other agencies which are in a better position to deal with the issues. So these are some of the mechanisms existing. You see, Malaysia have signed we have supported the adoption of UNPFII, the Declaration of Rights of Indigenous People in the General Assembly, when it was passed in 2007. Unfortunately, the government has not taken action to really implement it at the domestic level, meaning that we need to have a change of policy and to have a change of the law and existing legislation or new ones in order to mainstream, in order to incorporate the provisions in UNPFII. That is what is lacking now. So we are using updated legislation regards to land, forestry, with regard to enforcement of the rights of indigenous people. So that is a very big challenge. So as part of our recommendation, we recommend that in our national inquiry to land, that there must be a change of policy and law regards to land. Just one example. And the same refers to forestry legislation. So it is a big challenge for us, but we are continuing with our work. Like I said, we make use of the Parliament report and others. We also have discussion, networking. We improve networking with the civil society organization or NGO, non-governmental organization. They have to come to us, tell us the problem. Then we try to inquire and make reports. At the same time, we also foster closer relation with relevant government agencies because we are working with them. And to get them to cooperate and then to educate them on even on UNPFII and other legislation. That indigenous people are part of our society, part of the country, and they have their own rights, just like other sectors. They may be vulnerable groups, but that is why we have to help them to realize their rights. And we remind the government of their three obligations: to respect, to protect, and to fulfill the rights of each group, which includes the rights of indigenous people. So that is what we do. Thank you.
Recurring theme in the works of various national human rights institutions and Inter-American Court of Human Rights is the challenges to the rights of indigenous peoples by land and resource-based business operations, such as mining and agribusiness. How does each institution address with those human rights challenges of indigenous peoples? How can those business interests be respectful for indigenous rights? Please.
It's a very interesting question. Thank you, because it allows me to speak about one of the reports that I was mentioning earlier that we've published at the end of 2015 and that we've began disseminating in 2016. Our report on we call it on extractive industries, but it's on exploitation, development, and extraction activities, and of course that includes agribusiness and all major development projects. And so the Commission has been receiving a lot of information on the, I'd say, widespread implementation of these kinds of activities and projects throughout the Americas, and of the fact that most of these are being implemented on lands and territories that belong to indigenous peoples, in part because a lot of them are still pristine and protected, and therefore they're causing huge social, cultural, environmental, health problems with the communities. And a lot of these projects are implemented without proper free, prior, informed consent. So the Commission decided to publish this report in which it sort of fleshed out what all of the specific obligations of the states in the Americas were with regards to businesses operating within their territories, but also with regards to extraterritorial responsibility of states for the operation of their businesses abroad, right? And so the report established, for instance, the importance of having a very strong legal framework that addresses adequately both the presence of local and foreign businesses operating within the country. So it has to have a strong and effective legal framework. This legal framework must absolutely take into consideration and include strong environmental protections, as well as an obligation to have laws that protect free, prior, informed consent and consultation, as well as land rights, land and collective property of land for Indigenous communities, as well as effective tools to guarantee that the right is not only present in the law, but adequately implemented, no? So that's one of the obligations. Another one was to prevent violations of human rights that occur on the territories when these businesses, whether state-owned or private-owned, businesses operate on the land. So that includes measures such as guaranteeing that there's no violence against human rights defenders if they decide to oppose it, as well as monitoring mechanisms. So the state must guarantee that it has, from the moment that it grants a license or a concession to exploit natural resources on the territory, it must guarantee that it implements mechanisms, for instance, urgent communications. No, so if a community is suffering human rights violations, it will have a way to contact the state, inform it of the problem that's occurring, either the human rights violations or an oil spill, whatever can cause affectations to their rights, and the state can be triggered and try to prevent the problem before it becomes out of control. There's a lot of other obligations with regards to I wrote down a few. The supervising and monitoring, and this, it's important to mention that it's throughout the life project of the activity. So from the licensing all the way to the operation of the activity until the end, until it is shut down and terminated. It's very important that the state understand that it has a positive obligation to do this supervision, this monitoring of the business operations on territories. It's also extremely important that they guarantee effective participation of Indigenous communities, and that goes from their consultation, their right to free, prior, and informed consent, and also the importance of their participation in benefit sharing. And so if there is going to be a development project that's undertaken on the land or territory of an Indigenous community, they must not only be the ones that bear the burden of the consequences of that, but also that participate in the benefits that will be created by these projects. We also, there was also the importance absolutely of guaranteeing access to justice for Indigenous communities if any of these human rights violations are undertaken on their territories. And I mentioned earlier the Commission, I think this is something that's pretty groundbreaking about the report. The Commission mentioned that it was reasonable to understand that some states could be found responsible for the operation of their businesses abroad if they were aware that their businesses were operating abroad, committing human rights violations, and that the state that was the host of the business was not able or capable of guaranteeing access to justice for the communities that are affected. So it also mentioned the fact that in cases where states would allow what we call diplomatic or help or economic diplomacy, to sort of support. So the states will come and will help their businesses get in contact with the appropriate people in the state to find out how to get the licensing, etc. So if there's this help that's provided by this other state, then there's an obligation, it's an increased obligation on the state to make sure that when their businesses operate abroad, they respect human rights, right? Because the state has been sort of condoning and supporting the operation of these businesses. So that's one of the reports, and there's a lot more in the report, but I don't want to overextend myself. But it's an extremely interesting report that really has fleshed out a lot of the obligations that states have, which is our role, because what the Commission does essentially through these reports is explain what the standards of human rights are at the inter-American level and try to guide states in how to implement these. So now we're more in the implementation phase. What we're doing is doing a lot of training, and education on the content of the report. We've traveled a lot in different countries, met with states and with civil society organizations, indigenous communities to sort of explain what all of the rights contained in the reports are. And then we're hoping to see more and more litigation based on this for us to be capable of actually applying the standards that were developed on specific cases to protect the rights of indigenous communities. I should also mention, I think this is relevant, especially maybe for the people listening to us, that we have a new special rapporteur at the Commission on, which is DESCA, on economic, social, cultural, and environmental rights. And the first report of this new mandate holder is going to be on business and human rights. She actually just launched a questionnaire on the matter online, calling for civil society to answer the various questions that she poses on what the main preoccupations in terms of business human rights are. So that's interesting because the approach of this report might be closer to business and not so much to state responsibility for the actions of businesses, right? So it might be more specific. And so I call on everybody that's listening to it's part of the Americas to sort of answer the questionnaire and help us gather all the information we need to have an even better report to hand out or to publish. And there's a lot of other mechanisms, but I think I'll conclude with that to let my
Thank you. I do hope you send that report also to the companies worldwide operating in Americas. So, for example, European companies, so they can read thoroughly on their responsibilities. Please.
We absolutely do. I should just mention, I'm sorry, I should just mention in that regard that we've also been doing a lot of work with states, and I was mentioning economic diplomacy. My point is not to point out any specific states, but for instance, we've been following up on Canada. Canada is within the scope of the Americas and also has, and so it's a member state of the OAS. And we'd been following up on the contents of the report, trying to do some training, and they just came out with a wonderful, the creation of an ombudsperson that is going to be analyzing and receiving complaints with regards to the allegations of human rights violations committed by Canadian companies operating abroad. So I think we have to understand all of this as measures that are progressively being implemented in order to respect these inter-American human rights standards.
Thank you.
Yeah, thank you very much. In Norway and the other Nordic countries, the question of infringements in indigenous people's rights, so often questions on, for example, establishment of wind power plants, mining, water power plants, new infrastructure such as roads, etc. So the question often arises for the Sami people. So often comes to arise on how it will have an impact on, for example, reindeer herding or other Sami stakeholders in rights and interests in the areas and access to land, and of course loss of land, potential loss of land, and this is we of course been viewing this as primarily an obligation for the state to secure that the companies and that the companies are following that we have the rules, a set of rules that ensures that the human rights are properly followed and that they are realized. And but we see that there are challenges towards the human rights both as due to the processes before when the business project starts, and also when it comes to the results, as on the impact of the loss of land and so on. So we have put up this as a theme in our report to the Parliament, Norwegian Parliament, that these are real challenges that we have to look upon thoroughly, and of course I should perhaps have mentioned on the previous question that the Norwegian Parliament they do act and take very seriously on our reports on which of course covers all the human rights area and all human rights fields in Norway, but also our indigenous people's questions, and that the Norwegian Parliament has decided that and told the government that they want the government to come back to the Parliament with a report on how they are following up our suggestions to the Parliament and on how to better secure the human rights situation for all, and also for the Sami people. Furthermore, we are doing more specifically right now. We're doing an inquiry and a study on how the institutes, the legal institute on consultation, are being applied in Norway by the government authorities primarily, and we still haven't concluded and gotten all the results of the studies, but it will give an indication on how the processes in these kinds of questions are being handled by the government, by the authorities. And I think we can say that there seems to be quite various understandings of the meaning of consultations and the meaning of good faith in consultations, I think, and effective participation of the Sami people, and also on who is representing the Sami people in the question that arises in every single case, as it isn't only the Sami Parliament but also the stakeholders affected. So we haven't been working so much yet directly towards the businesses and the companies, but I think it's natural within the concept of business and human rights to focus more on that also in the years to come. Yeah.
Thank you.
Yeah, when we talk about challenges faced by indigenous people, including human rights defenders among them, we have to look into the current situation. One is, as I mentioned earlier, the legal and administrative framework which exists. And where do these people live? In the case of Malaysia, most of the indigenous groups, indigenous people, they live outside the town in the rural areas. They are basically agriculturalists, small farmers, subsistence farmers, and they need the land and the forestry to survive. And that's very important to them. But what do we have? They have very little rights. When you talk of UNDRIP, there's a long list of rights and privileges of indigenous people. But they have very little rights to self-determination, very little control over the resources in which they live and over the territory they live. Take an example. Under the land code, we have our land law in the state of Sarawak and similar one in Sabah. It provides that in one of the provisions, the state has overall control over the land, overall control. And there is a cut-off date for indigenous people to acquire rights over the land, customary rights. In the case of Sarawak, it started it used to be administered in 1840 for 100 years to 1841 by the Raja Brooks, which is related to is an adventurer from UK, from England. He administered it most like a family matters. He was given control because he helped to quell the rebellion. But after 1941, they took over by the British government. And in only 1963, Malaysia, through Peninsular Malaysia, became, and Sabah and Sarawak became independent in the formation of Malaysia. Peninsular Malaysia independent in 1957. So we have a long list of legislation. In the case of Sarawak, the land code specifies that you can acquire your rights over customary land if you clear the land before, say, 1955. But the law sort of incorporates existing legislation. So the existing land code says there's a cut-off date of 1958, 1st January. So meaning that if you clear the land before 1st January 1958, you have customary rights of the land. But if you settle on the land after that, you need a permit from the district officer or the administrative officer. And now it's under the officer from the Secretariat Land and Survey. So that is the situation. So we find that population increased, but the policy of issuing a permit exec was frozen in the 60s. So meaning that there's no more permits or new land to be opened up for customary land rights acquisition. So that is one situation. When it comes to forestry, mining, the law says all this come under state control. And if you want to extract it, you need a permit. But in practical cases, indigenous people have very little capital, fund. So in most cases, they don't get the permit to extract resources, whether it's mineral or some others. The same for timber resource. Timber resource and others are given to big companies because they have the capital. So the indigenous people are at a disadvantage. But they live in the land. So when large tracts of land is being issued under leases under land code, it may affect the settlement within it. The people who are already there, they may be illegal settlement. But as far as the people are concerned, that is their livelihood. They have nowhere to go if it is not recognized. So that is number one. The same for timber license. The state issue thousands of acres of timber license to private companies who have the capital. But very often the process itself is not transparent. So license are issued, the department given power to issue the license. But when it comes to operational of that timber concession, the big contractors are being given maybe second or third party. Enter the land, then the people realize there is a license which affects them. They have nowhere to go. They are trapped in between. So this is our situation in Sarawak especially. With regards to forestry concession, the other one is on land issued for big plantation oil palm or palm oil. The same situation, or for planted forests. These are issued to big companies. So the indigenous people are being caught in between. They become victims of so-called development because they don't have the resources, the power. So that is their situation. So because they live in the rural areas. So of course we have the government policy and also the government sort of programs to develop customary land through joint venture with private companies, but not always successful because at the end of the day there may be profits, but most of the profit is used for operational, and very little dividend is given to them. So that is because they have no choice, because they don't have the capital to develop the land, the customary land. So that is one. When it comes to forestry matters, yes, they can apply for customary forest, or we call it communal forest, for them to extract timber for their own use. Because they live in the villages, in the long houses. You have a village here. And what is important in Sarawak is that you have a small village or long house. That area surrounding it is their territorial domain. That is important for their livelihood, the forestry, because they take the produce for them, ranging from timber, even coffin for the people who are dead, fishing, hunting. And they need a small part of land for their farming. So this is the concept of you have the village here, the land area surrounding them is important to them. And they also preserve forests without cutting because they need timber. So in one of the recent court cases in the Tuan Rumah Sanda, December 2016 given out, there is this dispute about communal forest reserve surrounding a one long house, about a few thousand acres. The case comes to the federal court, with the highest court in Malaysia. They won in high court, won in the court of appeal, but when it comes to the federal court, the court rejected the claim of the natives, of the indigenous people, over this communal forest, or rather reserve forest, because they say it was not cleared as specified in the land code, so you don't have the rights. They have customary practice, admitted, but they say that the law defines in the country, in Malaysia, the law includes common law, written law, and law or custom which have legal effect. Now, whether that custom has legal effect or not, the court says no. Why? Because we have what we have is that we have a codified customary law. And that custom relating to land is not in the chapter of that codified customary law. So that's another basis. And this practice of so-called reserve forest was not expressly mentioned in the codified customary code, and also in some of the documents which exist since the 18th century up to now. So that is how the court interprets. Basically, a legal interpretation, very restrictive on the definition of customary law. And because of that, there is a huge outcry after December 2006 for the government to act. So now, luckily, the government heard a voice. Now the state government of Sarawak has set up a special task force to look into proposals to amend the land code to give recognition to this native customary tenure, including rights of communal or other reserve forests, which has been the practice all along, even though there are different racial groups, indigenous groups, but each of them have similar practices. So, but that sort of committee, they've done some work. They started a working group and they started a task force under the Deputy Chief Minister. And hopefully by July, when the State Assembly session is the government promised that they will look into the amendment. To what extent it recognized, we don't know yet. But the draft has been prepared, and we are hoping that they will give some general recognition of customary land tenure, including recognition of practice of that so-called reserve forest, which in our dialect we call it the Pemakai Minoa or Pulau Galau. Pulau Galau is basically a reserve forest left in that position for that to take natural resource from there. So that is important when it comes to land. And so that is the challenge faced. And when it comes to how do they enforce their rights? So what is being done in the case of a SUHAKAM or a commission? What we do is to advocate, or rather to educate them on their rights. We foster a network between them and us, and also the relevant companies, relevant agencies. At the same time, we facilitate dialogue between the indigenous groups and the government department, and also private companies. So one of the things we do is to promote this concept of human rights, and also which are affected by big industries, especially extractive industries, business and human rights. So we have a special project to provide a framework for National Action Plan on Business and Human Rights, which the government has accepted. So the details are being worked out. That is number one. Number two, our government has just approved and launched the National Action Plan on Human Rights on 1st of March this year. So which includes the rights of indigenous people in one of the chapters with regards to education, health, land administration. So we hope that, as I've said earlier, they have not taken action to implement UNDRIP. So pursuant to this National Action Plan, we hope that we will monitor. Our commission will monitor that, make sure the government take action to at least introduce legislative action, administrative, and also other measures to try to implement UNDRIP within the country. So that is number one. Number two, what we do is also that we, apart from the reports, we do follow-up action. And at the same time, remind government agencies of their obligations. And for the capacity building is important for the indigenous people, because for them, they need leadership. They need to have improvement in the system, and they don't have the money or the capital. So what we propose is that they must have legal aid to enable them to have access to court and justice. So legal aid, because our present legal aid system does not cover land administration or land disputes. So the government is more or less agreed to expand the scope of legal aid. One is with regards to assist them, the indigenous people. At the same time, when it comes to other mechanisms, they are trying to look into ways to improve apart from the courts. Of course, the native court also, they have to improve the administrative system so that accessible to indigenous people. And what is important is that we continue this dialogue, and our commission, Human Rights Commission, play the role not just facilitator, but we try to do our job independently, of course. And so far, we have good relations between the government and our commission, and also with the civil society organizations. But we need to work further to improve the networking. And at the same time, we have budget constraints, no doubt, but we try to recruit more staff and also build capacity building among our own staff so that we can better advocate for the rights of, especially for those indigenous people. So that is what I can share. Thank you.
Thank you. And we are about to finish now, but one last minute for each of you. What is your message to the indigenous peoples? What your institute can do in 1 minute?
Tough one. I think there's a lot of things that we could do, and I think it would be important for Indigenous peoples to know that there's options for strategic litigation and strategic use of all of the different mechanisms that we have, right? So we have mechanisms to protect, Indigenous peoples that are facing a situation of serious risk, of danger, of possible irreparable harm to their rights, so they can access precautionary measures if their lives or their physical integrity is at risk. There's also the option of thematic hearings to try to bring about understanding and knowledge from the international community with regards to human rights violations that are taking place on their lands, territories, and against the members of their communities. There's also the possibility to request visits of the Commission on their lands and territories for them to go see what's happening and be capable of reporting on the situation through thematic reports. There's petitions and cases, there's press releases. I think it's important to understand that the Commission is very much willing to help, very motivated, wants to support Indigenous people's rights, and has many different mechanisms that could be accessed by Indigenous communities. And we really hope that they consider this when they sort of establish and develop their strategy in order to attain these rights.
Thank you. Johen?
Yeah. Thank you very much. Yeah, we can follow up can do follow-ups on the situation of Indigenous peoples, in our case the Sami people, and on all themes of human rights, and we can report on them also, not only to the parliament and government and the Sami parliament, but also to the international treaty bodies such as the Human Rights Committee, where Norway were examined in March, and where we got quite a big response, good response on our inputs to the committee. We can also give advice to the in the legislative works, and also directly to the parliament authorities and the Sami parliament, and we can go into the public debate in various themes in media, and also try to give counsel on the development to a broader public, and such. And of course, all we do is based on thorough analysis of the law, and we are 17 persons working in Norwegian National Human Rights Institution, mostly lawyers and scholars, legal scholars. So I think that pretty much covers up what we are doing and what we are able to do. So I hope we will have an effect in the long run.
Thank you.
Yeah, in Malaysia, I have said before, it is important for Indigenous people to know that they have rights, as spelled out in the international instruments such as UNDRIP, Declaration on the Rights of Indigenous People. There's a long list of rights which they are entitled to and claim. And apart from that, we have the Universal Declaration of Human Rights, which is a starting point, which covers all, including Indigenous people. So at the national level, we have our own specific legislation. We have our federal constitution, which specifies the fundamental liberties, Article 5 to 13. Article 13 is important because it deals with rights to property, including customary rights to land. So that if it's taken away by the government for development, they are to pay adequate compensation. That is very important. Of course, they are not absolute rights, but it's important for them to realize that there's a long list of rights which they can claim. Number two, they have to make use of existing procedure, existing mechanism to claim these rights. If they don't have the resources, there are aids available, either through government funding, legal aid, but also through their own resources and other assistance. And there are bodies like our Human Rights Commission and other monitoring agencies administratively to receive complaints. And that is how they can utilize existing administrative and monitoring mechanism to assist them. And they need capacity building and they need training and others which can be provided. but they have to organize themselves and work as a team to really enforce their rights. And that is important for me. And that is why we need education, and we need to promote their rights. And by the same time, we work closely with them and to use the existing mechanism. And then apart from that, what SUHAKAM is trying to propose to the government is there must be implementation of free, prior, informed consent when it comes to development projects affecting indigenous people. And generally, the state, through their meetings, I think last year or so, as a result of our national inquiry report, the states have more or less agreed that this concept of free, prior, informed consent be implemented. Now they are working on the standard operating procedure. And maybe our SUHAKAM will provide inputs, and so are the other relevant agencies. So the Department of Aboriginal Affairs, Department of Malaysia, is providing a standard operating procedure to implement this FPIC. At the same time, as SUHAKAM, in our annual report, also in our report of national inquiry, proposed that there must be a human rights-based approach to all development projects so that the lives and interests of the indigenous people are taken into account. That has been absent in the past. So that is why they don't get the benefit of development projects, and there are problems of implementation which affect the rights. So that is another concept which we would like to see implemented. But like I said, it takes changes in administrative policy, the law, to put this in place. So because indigenous people, being an important part of the population, have their own rights. So it's important for them to realize. And at the same time, the government agencies and higher authorities, the politicians, the decision makers, must realize this. They cannot be left out as part of the country's citizens. So they have to fulfill their obligations as under obligation under the international and domestic law. So we like to see that in the years to come, indigenous people, especially defenders, human rights, are protected and their rights are promoted so that there'll be better opportunity for them to really enjoy the rights which are meant for them. You see, so that is my point. So we in SUHAKAM or Commission will do our part to monitor the situation and make reports. So in that way, we have to promote and protect the rights of indigenous people in Malaysia. Thank you.
Thank you. Thank you for all the panelists. And the message was that learn your rights and ask these institutions to protect your rights. Thank you.
Ologiit.
Thank you.
Thank you. Merci.